Hi friends, my name is Advocate Manish Chaudhary and today we are going to discuss about the legal news, conciliation, a voluntary process cannot be mandatory precondition for arbitration, Delhi High Court. The Delhi High Court made the observation while considering whether a conciliation clause in a contract was mandatory or directory. Conciliation proceedings are voluntary in nature and cannot be viewed as a mandatory precondition. Before the implementation of arbitration, Delhi High Court held earlier this week, Justice Naveen Chawla observed that even if a contract contains a clause for parties to first go for the conciliation process to settle dispute, such clause can only be directory and not mandatory. The judge acknowledged that conciliation must generally be encouraged and it should ideally be one of the first endeavors of parties when dispute arises. However, it must be borne in mind that conciliation is voluntary and can be terminated by the parties at any time, as per their free will, court said. Further, in case of urgency, arbitral proceeding can be intimated even while conciliation proceedings are pending. The court added while referring to Section 77 of the Arbitration and Conciliation Act 1996 to determine whether there is such an urgency or it is necessary to immediately invoke arbitration. It is the opinion of the party concerned which is relevant and the government factor. Thus, is so because conciliation, as noted herein above, is a voluntary process and by its very nature directory, it can be terminated at any point of time by any party. The court further explained. Applying these principles, the court found that the conciliation clause in a contractual dispute before arbitration was only directory. The said clause, Article 26, subsection 2, has stated that the parties to the contract should, in the first instance, attempt to resolve dispute amicably through a conciliation procedure. When a dispute